We are recording.
Thank you. Good morning again, everybody. The appellate court is back in session. This is the 10:30 case this morning. Victor DIAZ versus the City of Bridgeport and PMA Insurance Company, AC number 44104. First thing to do is have all the judges introduce themselves and then counsel for the various parties, starting with the appellant. I'm Judge Prescott.
I am Judge Suarez.
Justice Verdefe, you're muted.
Good morning, everyone. I'm Judge Verdefe.
Good morning.
Thank you.
Good morning, Joseph Passaretti for the City of Bridgeport and PMA Management Corp of New England.
Attorney David Morrissey representing the appellee Victor DIAZ.
Attorney Amanda Hackala on behalf of the appellant, the City of Bridgeport and PMA.
Okay, Attorney Hackala, you are not arguing this morning, correct?
No, Attorney Passaretti will be.
Okay. You may not have realized from the instructions that we sent you that we really only want one arguing attorney on the feed, just because it does create bandwidth issues and additional problems. You're welcome to stay on and observe the argument, but in the future, just kind of be aware of that, please. And just everyone should make sure that their microphone is muted while we're conducting the hearing when you're not speaking. That will help us reduce some of these issues. We are live streaming this argument on the Judicial Branch's YouTube channel. One of the things that means is that, and I don't think it applies to this case, but if there were to be any information whose confidentiality is protected by statute or rule, please be careful not to disclose that. Again, I don't think it relates to this case. You should have received the rules in the email. If you have any questions about those rules, please let me know. I will hold up a sign, very high tech when you're starting to run out of time. I know, Mr. Attorney Morrissey, you may not be able to see me at all times. And if you're running out of time, I'll let you know orally when you have about 2 minutes left.
Thank you. And by the way, I can see everybody fine right now.
Oh, great. Each side has 20 minutes for argument. If you're the appellant and you wish to reserve any portion of that 20 minutes for rebuttal, please let me know when your argument begins. I think that with that, we're ready to go. Attorney Passaretti.
Thank you, Your Honor. May it please the court. My name is Joseph Passaretti. I represent the City of Bridgeport and PMA Management Corporation of New England. If Your Honor would permit, I would like to reserve 5 minutes of my time for rebuttal.
You got it.
Thank you. This is a workers' compensation case brought under Connecticut General Statute 7-433C, the so-called Heart and Hypertension Act. It deals specifically with Connecticut General Statutes 31-302, which is what we refer to as the commutation provision of the Act. This provision allows the commissioner the discretion upon good cause shown to commute some or all of the worker's permanent partial disability award rather than have it paid over a period of weeks. Now, my brief is relatively short and my opponent's even shorter, and that's not to convey that this is a cavalier or unimportant issue, but very simply the fact that there's very little that the courts have said about this particular statute, and the legislative history is devoid of either direct or indirect guidance on how to deal with the issue before you today. So in essence, this is an issue of first impression. And I know you have the facts before you, so I won't go through them in detail, but the essential facts are that the trial commissioner took what was a 245-week award, and by virtue of the commutation statute, compressed it, but kept the weekly benefits intact and took the last 123 weeks of the award and commuted that into one lump sum.
Attorney Passaretti, could you
Yes, sir.
explain how many weeks he had received the weekly benefit?
Before the commutation?
Yes.
Approximately 10 to 12.
So he had been receiving the benefits for 10 to 12 weeks. There's a portion of at the very end of the period under which he's going to receive these benefits that have been commuted to a lump sum. So he's now, if this trial court decision, if the workers' comp decision were to stand, he would continue to receive a weekly benefit up until that date in which the commutation began and he got the lump sum prospectively. Did I get all that right?
100% correct.
All right.
So the conundrum here is a question of practice and history versus what the statute actually provides. For almost 100 years, the practice with commutation has always accompanied a period of what we call a moratorium or a holiday, consistent with the period of time of the commutation.
Attorney Passaretti, how do we know that other than you just telling us that?
Well, it's been codified into a form that is published by the Workers' Compensation Commission, which I understand is not incumbent upon you to follow, but the practice is evidenced by the fact that the very form published by the Workers' Compensation Commission called Commutation and What It Means specifically describes this practice. And in fact, the practice itself is manifest in the commission's order. The thing that we question is whether or not the moratorium period is a matter of discretion for when the commissioner can choose that moratorium to occur, or whether it must be contemporaneous with the period that's been commuted. Now, the commissioner here did not abandon the employer's right to have a moratorium. She simply moved it out to a period that's more than 2 years in the future. And that's the fundamental problem here, as Your Honor points out, is there's nothing in the statute that tells us that that's supposed to happen.
So, Attorney Passaretti, let me just see if I've got this in my mind. So, what I understand you to be saying is that what should have happened if he was going to be granted this commutation at, let's say, if he received it at week 15 out of the 245-week period, is that he would get the lump sum, he'd get his pension benefits, but the weekly payment for the first 123 weeks should have stopped and not recommenced until week 123. Is that right?
That is precisely my argument. Yes, Your Honor.
All right.
So in the absence of any statutory guidance, we are left to turn to equitable principles, if there are any, and we argue that there are, in fact, two. The first is the principle against double recovery. It's simply a matter of mathematics to say that the law dictates that the claimant's benefits here are supposed to be $511.13 per week. That's the law. That's what the order of the commissioner was in January of 2019. Now, my opponent will argue that, and the CRB observed, that this isn't a double recovery because the claimant is entitled to 245 weeks of benefits, and 245 weeks of benefits is what he's getting. But the order compressed the time by which those benefits are supposed to be received from 245 total weeks until 122 weeks. Now, doing that may not shock the sensibilities or the purse of a large workers' compensation insurance company, but the city of Bridgeport is not an insurance company. The city of Bridgeport is a self-insured entity. It is it has not only the right, but the obligation to budget the taxpayers' money and tax them only to the extent of reasonable and predictable losses. The city had the right to expect this award would be paid over 4.7 years. So in February 2019, by order of the court, they could have reasonably expected to pay the claimant another $9,400 in that fiscal year. Instead, this order served to require the city of Bridgeport to pay a total of $66,400 in a 22-week time period, for which they were only on notice for budgetary purposes that they would have to pay $9,400.
You are not arguing that there should be one rule for cases in which there is a insurance company providing the workers' comp benefits and another for when the provider is self-insured, the employer.
I am not making that argument, Your Honor, but I do believe that in order to invoke equity, that I also have to demonstrate a prejudice. And I'm not sitting here talking about a prejudice that would befall an insurance company because I can't make that claim. But I can say that this this activity, in the way that it was performed, does do an actual prejudice to a self-insured entity who is not only allowed but required to budget their reasonable and expected losses over a period of time.
The workers' comp system is a statutory system. Agreed?
100% agreed.
Right, and so and don't we have many cases that talk about the inapplicability of common law or equitable principles?
We absolutely do, but in a body of case law that is more than 60 years old surrounding Connecticut General Statutes 31-293, that's the subrogation statute. The equitable principle of against double recovery has been ratified and adopted by this court and the Supreme Court as applicable in workers' compensation settings. So inasmuch as certain equitable principles, for example, laches, which was objected by the Wibby court, double recovery is something that has been employed, utilized, and required to be adhered to in the context of workers' compensation. More so, there is an equitable principle surrounding the commutation statute itself, Connecticut General Statutes 31-302, that is found in the Reed decision, which is cited in our brief. The Reed court, I can give a citation if it's necessary, but it's in my brief. The Reed court talks about the commutation order being subject to a standard, and that standard is a just and reasonable standard. And the court breaks down that phrase so that it not just has a colloquial meaning, but it has a very specific meaning. And the just and reasonable standard requires the trial commissioner who is making a determination about the propriety of a commutation to determine not only that the commutation award is reasonable, and that reasonableness standard applies to the claimant who is seeking the award, but also that it is just. And the court explained that the just standard is in fact applicable to the employer. So the commissioner is bound to the competing equities of both the injured worker, who in this case, no doubt, was in a position to merit a commutation, but also a just standard, which is to balance that need of the claimant with the needs and the justice that is due to the employer. So in as much as we are dealing entirely within a statutory construct, we're also dealing within a statutory construct, which in many cases, including precisely and exactly within the confines of 31-302, that equitable principles are in play.
Reed is a 1935 case. Has it been cited regularly by our courts more recently?
I I do not know the answer to that question for certain, but I will tell you, Your Honor, in my research surrounding this case, there are no more than 4 or 5 cases in 100 years that deal with 31302. So my expectation that the answer to that question is probably not. So if you're troubled by the equitable principles, there are also some legislative principles from which I think we can draw some guidance, even though we don't have direct guidance about the legislature's intent under 31-302. What we know for sure is that the legislature, in promulgating the Workers' Compensation Act, certainly meant for there to be a maximum amount of benefits that an injured worker can receive. The legislature, by virtue of Connecticut General Statutes 31-309, actually sets a maximum compensation rate. For every single year, there is a threshold amount above which no injured worker can ever earn, regardless of their average weekly earnings that set the bar. So your average weekly earnings result in a roughly 75% amount of benefits to which you're entitled under workers' compensation. But every year the commission sets a ceiling for the most amount of benefits that you can make. Now in Mr. Diaz's case, his maximum workers' compensation benefit would be governed by the statute that was in place in 1989. His benefits at $5.11 and 13 cents maxed out at $671, which is to say that Connecticut General Statute 31-309 prevents anyone with a 1989 injury from making more than $671 per week. So the commutation award on its face serves to violate the maximum compensation rate, which there is a clear legislative intent to be in existence. And I know I only have 2 minutes left, and I just want to touch on the fact that the 7433C nature of this case also makes it unique in the context of a workers' compensation commutation, because unlike any other workers' compensation case, when you're in the Heart and Hypertension Act, there is a statutory cap under 7-433B above which an injured worker cannot exceed. Now, the way the cap works is a police officer making a pension and also a workers' compensation benefit cannot, when those two benefits are combined, exceed the amount of money that an active duty police officer today is making. Well, on any given week, if you take the amount of pension that he's making and the amount of workers' compensation he's making and give him $56,000, which is the commutation amount, well, that's on its face a violation of the cap, and it's a violation in any week that you do it.
So under that theory, the workers' comp commissioner could never give a lump sum, correct?
I believe that 31302 and 7-433B fly in the face of each other and are difficult to reconcile. And in as much as I don't have a specific notion as to how to reconcile that, I would say this: the commutation, to the extent the commissioner wished to award it, is still bound by the 7433B cap. So how could she have done it in a way that complies with the cap? And the answer is she could have crafted it in such a way that the weekly benefit increased, but not so much that it didn't exceed the cap.
Mr. Passaretti, you're out of time. You'll have 5 minutes for rebuttal.
Thank you.
Attorney Morrissey.
Thank you, Your Honor. This is a bit of an unusual case because people don't typically commute a portion of a permanency award. One of the things to keep in mind, and this is not part of the record, is unlike workers' comp benefits, heart and hypertension benefits are fully taxable as income. They are not considered part of the workers' comp statutes by the IRS. Hence the reasoning to get only a part of it commuted rather than the whole thing. To address Attorney Passaretti's points, we actually had a formal hearing, we call a trial, on whether or not it was appropriate to commute this to a lump sum. If there was some prejudice to the city that they couldn't afford it, they were in a financial bind, that would have been the time to put on some evidence that this would somehow prejudice them or hurt their budget for that particular year. There was no evidence presented at all, one way or the other, about whether or not this is something they could afford or whether this would mess up their budget for that year or any years in the future.
So, Mr. Morrissey, Mr. Morrissey, can you hear me?
Yes, I can.
So you're saying that contrary to the city's argument, there's just no evidence in the record of hardship if this ruling were affirmed?
There is no evidence at all, Commissioner.
Okay.
It was a very short transcript, and it was there was a comment made about, you know, giving deference to the city, but no one from the city came and testified about budgetary concerns about it or anything else to do with their finances. And did I answer your question? Okay.
Let me unmute just enough to say yes. That answers my question.
Okay, I'm sorry. This is a little unusual for me, so bear with me. It's my first one of these arguments. The other issue raised by counsel is that somehow he was getting double paid. Now, if he asked to have the entire award commuted to a lump sum, I don't even think we'd be here. And the commissioner easily could have commuted the entire award, all 245 weeks. So the back half of the award represents exactly that. It's a period of weeks, and I've actually broken down the weeks for your benefit. The first 122 weeks started on February 20th of 2019 and ran through June 23rd of this year, 2021. As of June 24th of 2001 and continuing through November 1st, 2023, his permanency award has been paid in full. So he's been paid for a period of time in the future, albeit he received it today. So it wasn't like he's getting 2 checks every week, which would bring the 7433 cap potentially into effect. In fact, if it's in effect at all, it would only be for that 1 week that he received the lump sum of the back half of the award. There's nothing that says this represents concurrent payment of $1,022 a week. He simply got the back half in one lump sum. The commissioner, it's totally in discretion of the commissioner as to whether or not it's just or reasonable to have commuted this award for Mr. DIAZ. We put on testimony. He talked about the financial hardships he was facing. Commissioner found that it was just and reasonable and agreed that a commutation was appropriate. Again, she could have commuted the whole thing, and I suspect had he asked, she might well have done that. If that was done, again, unless the city could convince the commissioner that they couldn't afford it and it wasn't reasonable to award the entire amount or part of it, they could have done that, but that did not happen. Again, because this is a discretionary award, I think the commissioner was well within her rights to do this. The CRB agreed that there was no double recovery. It simply gave Mr. DIAZ part of his award today and the rest of it on a weekly basis. Frankly, when I talk to clients about commutations, the example I give is I say, if I hired you to work for me at $1,000 a week for 1 year, I could give you some options. I could give you a check for $52,000 and say, don't bother me for 52 weeks. Or I could pay you $1,000 a week, or I could do any number of things. But the point is, for that 1 52-week period, I'm going to pay you $52,000. That's all that happened here, except it's a 245-week period. Mr. DIAZ is getting paid for 245 weeks, no more, no less. I don't think there's any prejudice to the city. This is what this statute was designed for, is to recognize that people that are out on comp are living on 75% of their take-home pay. Now, he does have a pension, I agree with that, but this allows him to make up for that lost income, pay those bills, pay the property tax that he couldn't pay, et cetera. Thank you.
Mr.
Go ahead,
Morrissey,
Justice Verdefe, go ahead.
is the city self-insured? Did you say that, or did opposing counsel say that?
The city is self-insured.
Okay.
Yes.
Thank you.
Thank you.
All right, Attorney Passarati, you have 5 minutes for a rebuttal.
Thank you, Your Honor. I just, Justice Prescott, I just want to point out that the Reed case, in response to your earlier question, has been cited a total of 4 times in Connecticut, the most recent time being in 1968. There is a Pennsylvania case that's cited to Reed in 2001. I'd be happy to provide those citations if Your Honor pleases.
That's not necessary.
Okay. I have nothing further to say in rebuttal. I would just ask that on behalf of the City of Bridgeport, we are requesting that you reverse the decisions of the CRB and the trial commissioner, or in the alternative, remand this case to the trial commissioner with directions to recalculate the commutation to be in compliance with the maximum compensation rate provision of 31309 and the cap provision of 7-433B. Thank you.
All right. Thank you, counsel, for participating in this hearing. Hopefully we'll see you back in the real courtroom sometime in the near future. We'll take the matter under advisement, and we stand in recess until 2 p.m. this afternoon. Thank you.
Thank you. Mm-hmm.